Article 5 is the key provision of the New York Convention. It provides the defences to enforcement, and in effect it provides for the mechanism by which enforcement is achieved. It has been the subject of widespread misunderstandings, partly caused by not reading it properly in connection with Article 7, and also failing to appreciate the point behind Article 5. Let me explain to you why. The first problem is a language issue again. The English approach says recognition and enforcement of the award may be refused, not shall be. There was actually a proposal brought forward by the German delegates to the New York Arbitration Conference to replace may with shall, which was, shall we say, not adopted. There have been some arguments about this. It's true to say there wasn't much discussion of it, and so one can argue there wasn't really a rejection of it. Nevertheless, the absence of the word shall may have a meaning here. And the meaning can strangely be found in the French version of the Convention, which again is the Spanish version. Recognition and enforcement of the award shall only be denied or refused if the party seeking to resist enforcement can prove one of the Article 5 grounds. It's that shall only. What the Convention does, it doesn't say you must refuse to enforce the award if one of the Article 5 grounds is proven. It says that these are the maximum defences that you are allowed to provide under municipal law to the enforcement of foreign awards. This ties in very nicely with Article 7, which, if you follow that approach, by the way, becomes almost irrelevant. Article 7.1 provides that nothing in the Convention shall deprive any party of a right to rely on any bilateral agreements on the enforcement of arbitration awards or domestic law. So you can see that the Convention was constructed on the basis that Article 5 would lay down the highest level of defences that the Convention could allow, but not the lowest level. And the European Convention of 1961 showed this up very strongly in its notorious Article 9, which allows a party seeking enforcement of the arbitration award to succeed even though the award has been set aside in its place of origin, so long as the ground for setting aside is not one listed in the Convention. This was one of the reasons why the Swiss and the British refused to ratify the 1961 Convention, because they both knew that they had grounds for setting aside awards, arbitraire for Switzerland, and for the UK, the case-stated procedure, which went considerably beyond anything in Article 9. So with that in mind, one can now look at the various defences. Article 5.1a is a pretty obvious one. It basically is the you don't have a valid arbitration agreement under the law that the parties have subjected to it, or failing any indication of that, the law of the seat of arbitration, or the law of the country where the award was made. The two terms, by the way, I use interchangeably, and most modern practitioners do, but the Convention doesn't use the word the seat of arbitration anywhere. The reason is because the term siège d'arbitrage, as it is called in French, hadn't really been developed at the time. People still talked about the place of arbitration, or the place where the award was rendered, rather than its seat. One of the more interesting and sillier arbitration cases, Hiscox and Outhwaite, concerned an arbitration award that the arbitrator signed in Paris and was unfortunate enough to have written on the award that he was in Paris at the time. The seat of arbitration was actually London, and the argument then sprung up as to whether this was a New York Convention award. In legal terms, he rendered that award in England, even if he didn't in physical terms. And English law was subsequently changed in the 1996 Act to make that pretty clear. The more technically interesting aspect of Article 5.1a is the defence that the agreement is not valid under the law to which the parties have subjected to the agreement, or in default of that, the place where the award has been rendered. This seems to give primacy of the parties' agreement over that place of arbitration. It doesn't realistically work very well as a result if there is a conflict between the two. In practice, lawyers around the world recognise that the place of arbitration, the place where the parties agreed to have their arbitration at least rooted, even if hearings take place elsewhere, is the law governing the arbitration agreement. And anybody who drafts an arbitration clause with a different applicable law provision stipulating for another country to govern the agreement, frankly ought to be checking their professional indemnity insurance, because it is going to cause chaos. It is really about time now that courts around the world stopped even considering whether the parties can contract out of the law of the seat of arbitration. In practice, in Europe, the European Union directive on this subject from the early 1990s makes it clear that an arbitration clause providing for future disputes will be presumed to be unfair and therefore invalid if it involves the consumer, and the UK has extended that to relatively small commercial claims.